appealing the matter of Phone EE Ltd and EE Ltd and others.
Yes, Mr.
May it please your lordship and your ladyship.
Yeah.
I hope the court will acquit me of discourtesy if I don't mention the names of all appearances. I hope they will.
I think we've worked out who.
In due course, they will introduce
Plenty of
themselves.
familiar faces.
Yes. My lord and my lady, this is an appeal by the administrators of Phones for You Limited from the judgment of Mr Justice Roth given on the 10th of November 2023. The judgment was severely delayed, coming as it did some 15 months after the close of proceedings in July 2022. Now, the learned judge refused permission to appeal on all grounds, and permission on 6 out of 8 grounds was granted by my Lord Chancellor. In our submission, the judgment under appeal misdescribes and misapplies key concepts of competition law. If it stands, it would amount to a denial of justice to Phones for You, and it would also amount to a clear signal to other victims of collusion. As the judge noted in his reasons for refusing permission to appeal, it is exceptional for a standalone claim for infringement of the prohibition in Chapter 1 of the Competition Act, such as the present, to be litigated in front of a single judge in the High Court. In our submission, if the judge's incorrect statements and applications of the law remain intact, the prospect of private enforcement for other victims of collusion will become even more remote, and would-be colluders could conclude that the risks of detection and being held to account are slim indeed. Now, there's another set of distinct problems in how the learned judge approached his findings of fact. Ordinarily, appeals about fact-finding rightly face a very uphill climb. But in our submission, this is a highly unusual case, and we submit applying the correct tests, the relevant grounds should plainly succeed. The learned judge was not entitled to adopt his own theory of facts to provide an innocent explanation for what would otherwise be evidence of collusion. He was not entitled to ignore evidence which all the parties at trial treated as critically important. Ordinarily, a judge who does not mention evidence is not assumed to have ignored it. But in our submission, because of the severe delay in this case, the radically different test, as we will see in the case of Matless and Bilter, for assessing findings of fact which applies as a result, is exactly the assumption which this court should make. Now, the respondents say it is understandable that the judge took the approach that he did to findings of fact. And they also say that disturbing such findings now, and having to rerun aspects of the trial many years after the relevant events took place, would be messy and undesirable. Both of these points are at least somewhat true, and they are in our submission irrelevant. Taking ground 3 as an example, it may be undesirable for a judge to confine himself to the cases as advanced by the parties, in circumstances where he considers that an uncanvassed and untested theory is a better explanation of what occurred. Now, in some jurisdictions, the learned judge could follow his own star, but not in this jurisdiction, where the authorities...
Sorry to interrupt you, Mr.
My lord.
McLean, because it was a point that troubled me a little. If the judge had simply said, well, I don't accept the case of collusion, and the information must have come from somebody else, but I don't say who, got no idea who the somebody else was.
Yes.
You couldn't really complain about it, could you? Or could you?
Well, if the judge, the way the judge approached this, my lord, was this. He found that our approach established a plausible case of collusion.
Yeah.
And having established that, we say that the judge cannot go off and find another theory, not tested, not canvassed by any of the parties. So that may not be an answer to the question that your lordship has posed.
Well, it may be. It may be.
But we say strictly following the approach in the Aalborg case, which the learned judge referred to, and the court is no doubt familiar with, if you follow that case, as we say the court should, having established that there is plausible evidence of collusion, the court cannot, in justice and fairness, go off and come out with its own theory long after the event. That has to be raised with the parties.
Well, I wondered about that. I mean, speaking for myself, I think if I'd been in the situation, I would have said, I would have been thinking, well, I better raise it with the parties, at least give them an opportunity to make submissions about it.
Yes.
Which, I mean, it's the sort of thing that does happen from time to time, particularly in big cases. But the judge didn't do that here.
No, he didn't.
No. Okay.
And that was quite wrong. Now, these proceedings, as you know, arise out of the collapse of Phones for You into administration in September 2014. Until that time, Phones for You had been a successful and ubiquitous presence on the high street, selling handsets and connections to the mobile phone networks operated by EE, Vodafone and O2. Phones for You's case was and is that it was the victim of collusion between some or all of those network operators who all ceased selling connections through Phones for You as a result of anti-competitive contacts between them. In our submission, in this case, there was a wealth of material which directly or indirectly led to the inference and conclusion that Phones for You was indeed the victim of collusion between its suppliers, including material evidence before the court that does not appear from the judgment to have been taken into account. Even on the basis of the judge's findings, my lords and my lady, what emerged at trial is, we submit, an astonishing array of anti-competitive behaviour, of coincidences and indicia, which amply supported our case, but the decisions taken by the mobile operators were taken under conditions of reduced uncertainty as a result of anti-competitive exchanges between them. All of this needs to be borne in mind, my lords and my lady, when the court comes to assess the somewhat dismissive, nothing to see here approach evident in the respondents' submissions on this appeal. I'm going to give the court some examples of the more general context before moving on to the specific grounds of appeal. But can I indicate to the court the structure that I propose to follow in my submission this morning and following? As the court will see, this appeal naturally falls into two parts. I propose to spend a good part of the day on grounds 1 and 2, which are the issues of competition law, and I will then address you on ground 3, which my Lord the Chancellor has just raised with me, the new theory ground, as we've been calling it. And then I will ultimately turn to grounds 4 and 5, which reflect the judge's factual findings and the application of the test in that rest and built up. My learned junior, Mr. Draper, will, at the end, address you in relation to ground 7, which relates to the judge's approach to adverse inferences arising from Telefonica's deliberate decision to take no steps to preserve relevant documents from wholesale destruction until long after a claim had been notified, and indeed in important aspects, even after proceedings were issued. Now, before I come then to grounds 1 and 2, there are introductory points about the context in which these legal issues arise and the series of events to which the factual grounds relate. The court has the benefit of a long and detailed judgment, and I propose to refer and focus on a few points by way of introduction. There are 5 key pieces of background, and I'll list them now before going on to unpack them shortly before the court. The 5 key elements are these. 1, the role played by Phones for You as an indirect retailer in the United Kingdom, and the so-called prisoner's dilemma facing the operators in seeking to reduce reliance on the less profitable sales which were made through the indirect retailers. Second point, the respondent's attitude to competition law compliance and the extent of informal and undocumented meetings in which senior executives either engage in naked attempts to collude or were at least reckless as to trespassing into unlawful exchanges of business-sensitive information. Third point, the meeting at the Landmark Hotel on the 19th September 2012 and the surrounding circumstances of that meeting. Fourth point, what we've been calling the Whiting Note and the meeting in Madrid between Mr. Hum of Vodafone and Ms. Castillo of Telefonica in September 2013. Fifth point, the evidence of communications between EE and Vodafone in 2014 in the lead up to their eventual decisions to quit Phones for You in mid-2014. My lords and my lady, taking each of those points in turn. One, Phones for You as an indirect retailer in the prisoner's dilemma. Phones for You, as you know, operated a very substantial business as an intermediary distributor, effectively bringing MNOs together with customers who would then contract with the relevant phone company. This was known as selling connections. And as you know, a customer would walk into a high street shop of Phones for You or visit its website to obtain a mobile phone contract, often along with a handset from EE, Vodafone or O2, or even Phones for You's own Life mobile offering. As the court knows, Phones for You was not alone in the intermediary business, but it was one of the largest, and the other largest operator was Carphone Warehouse. A key aspect of the factual background is that powerful intermediaries like Phones for You and Carphone were a peculiar feature of the UK market and were not seen on anything like the same scale in other European markets with which the mobile network operators were familiar. And as the judge records at paragraph 97 of the judgment, and I don't turn it up at this stage, the judge said the defendants, quote, did not like the strength of the indirect retailers in the UK market, which was, quote, the least profitable of the major markets in Europe. Indeed, my lords and my lady, the evidence at trial was that the defendants wanted either Phones for You or Carphone Warehouse dead and gone. For O2's part, its chief executive officer, Mr. Dunn, confirmed that reference in O2's documents to the, quote, the need for a, quote, structural change meant, quote, the exit from one of the indirect channels, and that indirect channel no longer existing after a period of time. The reference for that, which we needn't turn up, is supplemental bundle 3, tab 127, page 1477. As regards Vodafone, the judge accepted that the evidence supported Phones for You's case, that Vodafone's decisions to exit Phones for You was predicated upon an expectation that Phones for You would cease trading, and moreover, this was precisely what Vodafone wanted. Reference for that, paragraphs 400 to 403 of the judgment, where the learned judge sets out several passages from contemporaneous documents. In this context, the judge also records what he called the, quote, disreputable subterfuge Vodafone engaged in to deceive Phones for You into believing that a contract renewal would be forthcoming after the point in time when Vodafone had in fact committed to an exclusive arrangement with Carphone Warehouse. And the reference for that is paragraphs 384 to 91 of the judgment. The whole point of that subterfuge was to prevent Phones for You from committing itself to making other arrangements that would help it to survive Vodafone's exit. In the judge's words, the purpose of the subterfuge was, quote, to discourage Phones for You from pursuing any alternative strategy. Paragraph 391 of the judgment. Lastly, as regards EE, its parent companies, Deutsche Telekom and Orange, had, quote, long wanted to reduce the hold of indirect distribution on the UK market, close quotes, and considered that following an exit by EE, quote, the collapse of Phones for You was a better outcome than its survival. And the reference for that is paragraph 713 of the judgment. And when the time came to exit Phones for You, EE mused internally whether it had, quotes, the killer blow that it needed to put Phones for You out of business. Paragraphs 716 to 717 of the judgment. Now, there is nothing inherently unlawful with wanting a trading partner out of the way. The defendants could have admitted at trial that they wanted Phones for You to cease trading and contended that they pursued that objective by uniquely lawful means without any collusion or illicit cooperation. It was and remains telling that they took a very different course and put up witness after witness who denied on oath the position revealed by the contemporaneous documents. The judgment is remarkable for how many of the defendant's key witnesses were found to have been less than straightforward and frank. As the judge said in another context, the witnesses, of course, understood the nature of the allegations in this case. And those allegations included Phones for You's case and the significance of the prisoner's dilemma, which faced all the MNOs. Now, this meant that any MNO which exited alone, without a measure of comfort that its competitors would follow suit, faced the risk that those competitors would take advantage of its exit to sweep up the volume of connections that Phones for You had previously provided to the exiting MNO. We've compiled a list of references for that point at paragraph 10.2 of our supplementary skeleton, which is at core bundle 201, and I wonder if I might ask the court to read that passage to yourself. Supplemental skeleton, paragraph 10.2 on page 201 of the core bundle.
Core bundle. So which tab is we take?
It is tab 9 of the first volume of the core bundle.
Yeah.
Paragraph 10.2.
Oh, yes.
Your Lordship's ladyship have obviously seen this. My point is this: if one looks at the last sentence of the last extract in this paragraph, this entrenched the view that to, quotes, walk away from Phones for You required, quotes, an industry-wide approach, not a random let's hope everyone follows. In our submission, is a fairly remarkable thing to be recorded in an internal document when discussing the potential actions of close competitors, but it's just one example of the culture in which these mobile phone networks operated. And lastly on this subject, may I show the court paragraphs 101 to 103 of the learned judge's judgment, which is in page 289, tab 18 of the first court bundle. The court will see that this concept of provision, the prisoner's dilemma, is not one that was invented for the purposes of this trial by my clients, but was recognised at the time. Now, of course, the prisoner's dilemma would not get Phones for You home on its allegations. Of course, we accept that. It established, however, a strong incentive for MNOs to reduce the risk and competitive uncertainty involved in any actual or potential decision. And the key question, as the learned judge identified, is how the defendants went about it. But the dilemma is also important for this reason. Since all the MNOs recognised its existence, it would not take much by way of informal contacts between them for the uncertainty it created to be reduced, and for proposed unilateral moves away from an indirect channel to be de-risked. In this context, one of the canards that the respondents repeatedly advance in their submissions on appeal is that Phones for You's case requires it to establish that the MNOs had collusive plans or agreements to exit from Phones for You. It does not. In fact, collusive exchanges of information were all that was needed to temper the risks presented by the prisoner's dilemma, which in our submissions we shall see the evidence revealed. Now, that brings me to my second point, the important context of the defendant's attitude to compliance with competition law in their taste for informal, undocumented meetings with one another. In many contexts, one might be sceptical of the idea that senior executives in major undertakings would be prepared to resolve the prisoner's dilemma by illicit coordination. But in our submission in this case, there was no room for even the slightest scepticism about that. First, although each of the defendants had competition law compliance policies, the judge found, quotes, that a number of very senior executives in various defendants paid scant regard to some of the recommended precautions about contacts with competitors. That's judgment 94, paragraph 94. There were, in fact, numerous informal and undocumented meetings between senior executives of these competing undertakings, with each of them very deliberately taking the legal risks that competition law compliance policies were designed to minimise. The second aspect, my lord, is that the defendants were not shy about using these opportunities to sound each other out on confidential and business-sensitive matters, straying more or less willfully into collusive behaviour. One remarkable aspect of the judgment is that despite finding against Phones for You on the alleged infringement, the judge nevertheless found the defendants to have repeatedly engaged in attempts to collude, or have at least strayed into impermissible territory. And I can give you 6 examples from the judgment. First, and most obviously, Mr Dunn's approach to Mr Swanty at the Landmark Hotel in September 2012 involved, as the learned judge put it, at paragraph 197 of his judgment, an invitation to collude. EE chose not to object to the invitation or to immediately protest about it, let alone to report it to the authorities, preferring not to rock the boat in its strained relationship with O2. And I will come to address this particular episode in detail under grounds 1 and 2. Second, Mr Lawrence, the Chief Executive Officer of Vodafone, telephoned Mr Swanty in October 2012 to discuss and to influence the price at which EE should pitch its new 4G connections. Judgment 164 to 167. Third, at around the same time, Mr Dunn of O2 had a collusive conversation with Mr Lawrence in relation to 4G pricing. The reference for that, judgment 238. So the picture which emerges is that each and every one of the MNOs was involved in collusive contacts in relation to 4G pricing. This was a market in which even the starkest, most well understood type of collusive behaviour, price fixing, was apparently fair game for O2 and Vodafone. And where they were so obviously unconcerned about the risk of a report to the authorities that they made more than one approach to EE. Fourth, in November 2012, Mr Dunn sought and obtained from Mr Lawrence commercially sensitive information as regards Vodafone's approach to negotiating with Apple, and then tried to obtain equivalent information from Mr Swanty in the hope of encouraging all MNOs to adopt the same strategy to negotiations with Apple. References for that are the paragraphs 170 to 174 of the judgment. Fifth, in mid-September 2012, Mr Hum of Vodafone, 2013, Mr Hum of Vodafone met Ms Castillo of Telefonica in Madrid. Mr Hum said that he wanted to obtain from Ms Castillo information as to whether Telefonica, quotes, felt good about having exited from Phones for You, although at the time, O2 had not yet fully exited from Phones for You. The judge found that while Ms Castillo's response to Mr Hum's approach may have, quotes, crossed the boundary of anti-competitive exchange of information, she did not give any information on O2's future commercial strategy. Judgments 287 to 292. Finally, in April 2014, Mr Sheen of Orange, also a director of EE, sent a text message to Mr Hum of Vodafone to arrange a short call, as he put it, 5 to 10 minutes max, to discuss, as he put it, quotes, a topic for the UK market. The two men then spoke for around 5 minutes on the telephone. Both said at trial they had no recollection of the call, which the learned judge found, quotes, somewhat surprising. Judgment 569. Neither of these gentlemen gave a satisfactory explanation as to what they discussed. Mr Sheen, following the conversation, proposed by text message that the two men speak again in short order on, as he put it, new prepaid mobile phones, colloquially known as burner phones, so that, as he put it, the call would be secured, a euphemism for untraceable and leaving no record. Now, the judge rejected Mr Sheen's evidence that the call was about network sharing and found that Mr Sheen was likely exploring with Mr Hum the possibility of a joint acquisition of Phones for You, conduct that the learned judge said would be an understatement to call borderline behaviour, but which was not the collusion alleged by Phones for You. Judgment paragraphs 562 to 574. Now, I will come on to address, probably tomorrow, but if the full context of the 5-minute call between Mr Sheen and Mr Hum is taken into account, including vital evidence that the learned judge is not referred to in this section of the judgment, it points almost inescapably to the conclusion that the conversation involved consultation around exiting from Phones for You rather than a joint acquisition. Standing back from that specific example, in our submission, the overwhelming impression is a market in which the principal competitors had no scruples whatsoever about engaging each other in attempts to collude, and in which nobody ever thought fit to make a report to the authorities. We have collusive approaches from senior executives in every one of the undertakings. Mr Sheen for the undertaking comprising EE, Orange and Deutsche Telekom, Mr Hum and Mr Lawrence for Vodafone, Mr Dunn for O2. And there's one more incident that I should mention before moving on. Following the public announcement in 2014 of Vodafone's decision to leave Phones for You, and knowing that EE had decided to do the same, EE took steps to set up a meeting with its regulator, Ofcom. Its object was to forestall any questioning from Ofcom as to whether there might have been coordination from Vodafone and EE, given what might appear to be the case to an objective observer from the sequence of events. In that connection, EE presented the regulator with a very misleading timeline of its decision-making. It falsely suggested that EE had decided in principle to deal with Carphone Warehouse as its main partner in March 2014. The judge addresses this episode, the paragraphs 609 to 615 of his judgment, in a section entitled A Series of Unfortunate Events. He described EE's conduct as deplorable, but went on to say it did not lead him to change the conclusion he had otherwise reached on the issue of collusion. My lords and my lady, the third of my 5 points is the landmark lunch. The judge accepted Phones for Use case that the key context of the meeting was that O2 was looking to de-risk a provisional decision had taken the week before to exit Phones for You as regards new communications. Mr Dunn was tasked with approaching Mr Swampy and sounding him out as to how EE might react to the impending move. References for that are Judgment 147 and 197 to 198. Further important context was that Mr Swanty himself was keen to de-escalate a controversy that had arisen between EE and O2 as regards EE's early launch of the new 4G service. Relations between the two companies had become fractious, and Mr Swanty wanted to smooth things over. Judgment 148 to 152. That was, of course, around the time as Mr Dunn and Mr Lawrence were attempting to involve EE in price fixing for its new 4G services. As I said, I'm going to come in detail to what happened at the landmark lunch under grounds 1 and 2, so I'll leave it there for the moment. But we are going to submit that if it really be the case, as the judge found, that the law condones and does not sanction the sort of anti-competitive contact that Mr Dunn and Mr Swanty had at the landmark lunch, then Article 101 and its domestic analogue do not strictly preclude or preclude at all contact between competitors with the object of influencing each other's conduct in the market or disclosing their own actual or anticipated conduct. If the judgment stands, such conduct is apparently lawful, provided only that the undertaking subject to the anti-competitive approach does not provide a positive indication of support for the other's collusive objective. Fourth, the meeting between Mr Hum and Ms Castillo in Madrid in September 2013. For present purposes, it's worth noting that this meeting was only a few months before Mr Dunn met Mr Whiting in January 2014 and told him that O2 could not sign a deal because of commitments given by Telefonica to Vodafone. If you could turn, my lords and my ladies, to the judgment, paragraph 276, you'll see that the learned judge there sets out the full text of this email, which was an internal Phones for You email where Mr Whiting had set out for internal legally what had happened at this particular meeting. Now, as the court knows, the learned judge had made certain findings about this, which we're going to explore when we come to grounds 4 and 5. But the important point for now is that Mr Dunn specifically mentioned in this extract that we have here the fact that there had been a communication between Mr Hum and Ms Castillo. And we now know from the scrappy handwritten notes of Mr Hum, which survive, that he at least intended to raise with Ms Castillo how Telefonica felt about having partially exited from Phones for You. And the judge found, despite Mr Hum's denials, that he did indeed raise that topic with Ms Castillo. All in our submission, a remarkable coincidence, if, as the judge concluded, Mr Dunn was making up what he said to Mr Whiting. The supposed lie came at least very close to the truth as revealed in the contemporaneous documents. Fifth, evidence of contacts between EE and Vodafone in 2014. As is typical in this type of case, the evidence is principally that information was passed as opposed to evidence showing how it was passed. Important evidence indicating that information was passed includes the subject matter of ground 3. That's an email which, as the judge found, showed that EE had obtained confidential information indicating that Vodafone was going to exit from Phones for You. Further evidence showing that information was passed includes the sharp change in May 2014 in EE's modelling of various possible outcomes of exit from Phones for You, which Phones for You's case was informed by assumptions the modellers were instructed to make, which were themselves derived from improper contact with Vodafone. Phones for You recognised that it is rarely possible to be precise about how information of this kind is conveyed. There was, however, one potentially very important indicator as to how at least some information may have been passed, and I've already touched on the approach by Mr Sheen to Mr Hum and his suggestion of continuing their dialogue via burner phones. In terms of setting up the submissions I'm going to make about that, it's worth noting what the judge said at paragraph 573 of his judgment, quotes, "I think it is important to consider this exchange in context, and we respectfully agree with that observation. But the fundamental flaw in the judge's consideration of that exchange is that it paid no regard to key material that provides the context, and which makes it extremely unlikely that the topic for consideration was, as the judge held, a joint acquisition of Phones for You, as opposed to something more sinister. In circumstances where the judge rejected Mr Sheen's, quotes, evasive and unsatisfactory evidence about the topic of the conversation and concluded that Mr Hum's evidence may well have been less than entirely frank, in our submission it was essential that the judge should have had regard to the full context and assess the issues on the balance of probabilities in the light of all the material evidence. And the reference for the judge's comments on the witness evidence are in 571 and 575 of the judgment. My lords, my lady, the last introductory topic is document loss and destruction. I've already referred to Telefonica's disgraceful decision to take no steps to prevent wholesale destruction of potentially relevant documents, despite being on notice of a claim. They were no doubt the worst offender, but they were in good company. By way of outline, as the court knows, Mr Swanty of EE made a recording of part of the meeting with Mr Dunn at the Landmark Hotel. Mr Blendis, EE's General Counsel, made a transcript of the recording, which was apparently kept in a folder on his desk marked Phones for You. Both the recording and the transcript disappeared by the time of trial, and if there was a CD of the recording, which Mr Blendis said he thought there had been, that too had gone. Judgment 191 to 192. Orange, quotes, inadvertently, close quotes, omitted to preserve documents on key custodians' iPads and mobile phones. That included Mr Sheen's emails and mobile phone records. As for Vodafone, it apparently preserved mobile phone and email data on a hard drive, which it said it had lost by the time of trial. Mr Herdenkamp of Vodafone, despite apparently being told by solicitors to preserve records, threw away his contemporaneous notebooks and relocating to the Netherlands. This, in our submission, was all important context. The judge's task in drawing together the threads and making appropriate inferences in the absence of anything like a complete documentary record. Now, those are the introductory points I wish to make by way of context. Before turning to grounds 1 and grounds 2, may I ask to be handed up to the court what we regard as key questions which are going to be, the court is going to be invited to consider in the course. It's a 2-page document.
Have the respondents' counsel seen this?
They haven't seen it. But they will see it. They'll see it soon. Your Lordship will see when you see it, and they will see when they see it. It traverses the issues which are appear in the skeleton.
Yeah.
It's double-sided. And I'm going to be addressing the court on these, what we describe as key questions, during the course of my submissions. Now, in framing grounds 1 and 2, I'd make a number of preliminary points. The model of competition protected by Article 101 and its domestic analogue is that of autonomous market participants competing against one another and making their policy decisions and taking decisions independently of one another. According to long-settled law, the requirement of independence strictly precludes direct or indirect contact between competitors whose object or effect is to influence the conduct on the market of an actual or potential competitor, or to disclose to such competitor the course of conduct which they have decided to adopt or contemplate adopting on the market. As EE recognised back in 2012, Mr Dunn's approach to Mr Swanty at the landmark lunch involved the disclosure by O2 to EE of O2's highly sensitive and confidential information which could only have been made to influence decisions by EE. And the judge rejected EE's case at trial that it had objected at the time of the anti-competitive approach or publicly distanced from it thereafter. In our submission, in the light of the legal policy inherent in Article 101, and in the light of what EE plainly understood to have occurred back in 2012, it is difficult to understand how or why, a decade later, when Phones for You's administrators sought to hold O2 and EE to account, that they should be absolved of a breach of Article 101. Something seems to have happened to transform what on the face of it EE recognised in 2012 as a plain violation of the strict preclusion against competitors engaging in direct contacts to influence each other's conduct on the market, and therefore unlawful, into a lawful meeting.
Do you
In our
just
submission,
understand, because this is obviously a critical area of the case.
yes,
In just putting it in simple terms, Mr Dunn tells Mr Swanty what O2's intentions are in relation to Phones for You, or that they're going to reduce it, their participation in the indirect market. Mr Swanty doesn't say anything, but Mr Dunn derives, as it were, succor from Mr Swanty and thinks, well, that demonstrates that they may very well follow suit. That, assuming that's the effect of all this, do you say that is sufficient in terms of anti-competitive conduct if it gives the encouragement to the discloser?
well, I'm going to have to unpack that, my lord.
Yeah.
And the reason I'm going to have to unpack that is because it is clear from the judgment that Mr Dunn did not express himself in precisely the way in which your lordship has put it.
No, understood.
But we do say that when we come to look at the judgment, the judge recognised that Mr Dunn was making to Mr Swanty an invitation to collude. That's how he described it.
Yeah.
And we also find that while Mr Dunn expressed himself in circumspect terms, Mr Swanty, the addressee, the highly intelligent and experienced Chief Executive Officer of EE, understood the thrust of what was being said. Now, in our submission, that is entirely
The
inconsistent.
judge actually finds that specifically.
He finds
understood
that.
the thrust
Yes,
of what
he does. Mr. Swanty understood. And that in our submission is completely at odds with the requirement for strict independence. In the case I'm going to show you, it's called Sauco Unia, a long-standing and well-understood principle of the interpretation of Article 101. So I don't want to give the court a false impression about precisely how precise Mr. Dunn was in his approach.
No.
But we say, in the light of what the judge found about the approach, it's a bit difficult to understand how it is that consultation, the first element of a concerted practice, was not found. And I'm going to go on to explain to the court that that seems to be because the judge made two fundamental errors of law. I'm going to address you on both of those. Yeah. And those appear in paragraph 217 of the learned judge's judgment, which I will address you on in detail. But
Mr. McLean, can I just clarify? The question put to you was
yes,
whether your case on appeal is about the impact on, let's call them the disclosure at the moment.
Yes.
Mr. Dunn, the disclosure.
yes.
I don't think you've, if I may say, I don't think you've quite answered that.
I'm sorry.
The thrust of your skeleton argument on ground one,
Yes.
as I read it, and your focus on paragraph 217
Yes.
and 225
Correct.
appears to be the impact on the disclosure.
Correct.
But I'm not sure that's the submission you've just made. You've
Well,
just made a broader submission.
I have made a broader submission. You read it.
That's why I asked the question.
But I am not resiling one iota
So
from the
if
from
don't
the
mind how it was expressed, but if Mr. Dunn comes away
Yes.
with a sense of encouragement that if O2 pulls out, then the others may follow,
Yes.
that's sufficient.
Absolutely. Because that distorts competition. It is
Because that was the
inconsistent.
point that speaking for myself, I found bits of the judgment slightly surprising on this part of the case.
Yeah.
But what's said against you is, well, he used loose language in some parts of the judgment. When you add it all together, it's correct as a matter of law, and that's effectively what's said. And what's said then is, well, what you're really trying to do is to challenge findings of fact. This court shouldn't go near that with a 10-foot barge pole, putting it colloquially.
Can I just follow up with one more? What do you say? We've talked about the position of the disclosure. I've seen very little, I've got very little from your skeleton about the position of the recipient,
Yes.
which is, I think, was what you're talking about in your broader submission.
Yes, I was.
What is your case on that?
Well, our case on that is it's an extremely surprising decision, frankly.
But is it something you're
For present
not
purposes,
clearly
we're
how-
not on this ground, no.
right?
On this
so
ground,
that really does
Yes.
answer the question.
On
Your
this
focus
ground-
in ground one
Yeah.
is on the position
As
of
regards, yes,
Mr. Dunn
Yes.
and what, if any, comfort he obtained.
absolutely.
Thank
And there are two reasons I'm going to come to in the course of
Yeah.
my submissions
Yeah.
as to why the learned judge was wrong to impose what we say is an additional or too restrictive hurdle in relation to the two-way communication. There's essentially a two-way communication. Dunn says whatever he says. The judge records what it was that Dunn said, playing big cards. The response, according to the judge, pure passivity, itself conveys information to the approacher. And I'm going to expand on that in the course of my submissions. And the information that is conveyed to the discloser is capable of distorting competition. Information is received by the discloser which he didn't ought to have on the basis of the strict preclusion of an approach to a competitor.
Does it continue in a sense, because you've pointed out that Mr. Swanty subsequently, immediately after the meeting, is sufficiently concerned to raise it with General Counsel, who, as it transpires, is sufficiently concerned not only to transcribe the iPad conversation, or the bit of it that's on the iPad recorded, but also to go to Slaughter and May.
Yes.
And to discuss whether or not there should be a self-report to the competition authorities.
Indeed.
Do you say that the failure to do that is all part and parcel of what would give Mr Dunn encouragement, or?
Yes. Yes.
So it's a sort of continuum of
the only
communication the other way, if I can.
Yes. The only appropriate response that Mr Swanty should have had at the meeting on the 19th was to say, I'm sorry, Ronan, Mr Dunn, or however they addressed each other, we will have no part in this. That's the only appropriate response. Let's not forget that these were the two most senior people in these organisations. They are not junior salesmen. They're sitting down together at lunch. The only appropriate response that Mr Swanty could have had to the approach by Mr Dunn was, forget it, I'm not interested, please stop talking about this. And let's not forget.
But equally, if he'd said nothing, as he did,
Yes.
but a week later or whatever, there'd been the self-report to the CMA,
Yep.
then that would also preclude collusion.
It would.
Because that would be
Public distance.
sufficient public distance.
It would. It would. Exactly.
Yeah, okay.
But I'm very happy to address the court on issues that trouble the court. And of course,
Sorry, we're taking you out of your course. But
Can I?
see, these are the issues that
They are the issues, and I'm hoping to explore those issues with the court in the course of my submissions on ground one. Now, the key events in relation to consultation is, in my submission, the following. Dunn, the Chief Executive Officer of O2, makes a nakedly anti-competitive approach to Swanty in a face-to-face meeting. And the learned judge himself found that it amounted to an invitation to collude. Judgment 197. And that Mr Swanty himself understood this. Judgment 199. This meeting occurred at a crucial time in the negotiations between O2 and Phones for You. Judgment 234. The purpose of Mr Dunn's approach was to try to de-risk the provisional decision that O2 had taken the previous week to exit Phones for You for new sales by sounding out EE's reaction to O2 reducing sales through the indirect channel. So this approach involved one, an attempt, an unlawful attempt to influence EE's market conduct, and two, a disclosure to EE of actions that O2 was contemplating taking in the market. As I've said, this is the very antithesis of the legal requirement for actors to act independently. It involved the breakdown of the free competition model upheld by the prohibition in Article 101 and the case law which interprets that. As EE notably saw things at the time, and I wonder if I could ask you to look at judgment paragraph 180, which is page 313 of Core Bundle 1 tab 18. Now, this is you'll see a passage, quote in quotations, indications of intentions to encourage. Your Lordships and your Lordship see that. This was a document prepared by EE's internal General Counsel, Mr Blenders. It had the input of Slaughter and May, and it also had the approval of Mr Swanty. And it was prepared as a sort of script for Mr Blenders to approach the General Counsel later in late November or December, it doesn't matter when, to raise with them the approaches which had been received. And you'll see what it says. Included references to actions by O2 that would otherwise be highly sensitive and confidential to the O2 business. and could only have been made to influence decisions by EE to support such actions. For example, with reference to value in the distribution space, O2 was indicated to be willing to play some big cards. Now, despite this nakedly anti-competitive approach, despite Mr Swanty's understanding the thrust of what Mr Dunn was saying, and despite Mr Swanty's failure to object to it, the judge concluded that there was no consultation. And our essential complaint is that in reaching that conclusion, he applied too narrow and restrictive an approach to what qualifies in law as consultation. His approach undermines the strict preclusion in law between contacts between competitors with the object of restricting or distorting competition, and also undermines legal certainty. Now, I'm going to start with outlining the application of the concept of a concerted practice to anti-competitive disclosures and invitations to conclude, including the treatment of passive responses in the authorities. And I will then come on to address the two factors the judge in our submission wrongly saw as negating collusion in this case. Now, the court will have seen that there are a number of helpful submissions made by the CMA before the court in relation to the law. And in its submissions at the outset, the CMA stresses the importance of being able to prove infringements in the face of secret consultation and necessarily limited evidence. And we also emphasise that point from the perspective of private enforcement. An important aspect of the concept of a concerted practice in facilitating the enforcement of competition law is its flexibility. And this court said in the Argos case, concerted practices can take many different forms, and the courts have been careful not to define or limit what may amount to a concerted practice for this purpose. That's the Argos judgment, which we have in the bundles. I don't go to it at this stage, but for your note, volume 3, tab 10, page 529, 537. Now, the flexibility of the concept of a concerted practice has not inhibited the development of clear principles that promote legal certainty by giving a predictable outcome in a given set of fact patterns. And one of those basic fact patterns is this: a competitor makes a collusive approach to another, which might involve an express invitation to collude, or the disclosure of business-sensitive information. In either case, as the case law makes clear, such an approach is treated as having the object of restricting or distorting competition. And the recipient of the approach responds only passively, or in other words, does not actively take up the invitation to collude, nor actively objects to it. That fact pattern involves contact between competitors that is inimical to genuinely independent conduct, which is strictly precluded by Article 101. And we see this from the classic exposition of the Article 101 prohibition in the Sauka Unia case. And if I could invite the court to take that up. It's volume 8, tab 34 of the authorities bundle, page 1804. It's a decision back in 1976. So this exposition of the law has stood for nearly 50 years. And the court on page 1914, I think it is, we could turn to page 1914, towards the bottom of the page, 1914, not 1814.
1914.
Yes. Summary of the relevant statements of the decision and the main arguments of the parties. We've not sidelined this, I apologise. 30 through to 36. 3 gives you the thrust of the facts in this particular case. So, bottom of 1914 over to 1915. But the key paragraphs I wish to direct the Court's attention to is on 1934, paragraphs 173 to 174. If I could invite the Court to read the sideline passage at 173 to 174. So the Court sees there that there is a distinction made by the European Court of Justice between intelligent adaptation to anticipated conduct on the one hand and collusion on the other. Mm-hmm. And the strict preclusion is expressed in clearly disjunctive terms. Direct or indirect contact between operators, the object or effect of which is either to influence the conduct on the market of an actual or potential competitor, or to disclose to such competitor the course of conduct which they themselves have decided to adopt or contemplate adopting in the market. And on the judge's findings, the approach by Mr Dunn to Mr Swanty had both of those impermissible objects. It had the object of influencing EE's conduct, persuading EE to cooperate with O2, and the object of informing EE of the course of conduct that O2 contemplated adopting in the market. As I've said, and according to the judge, EE well understood the thrust of what it was being told and what it was being asked, namely to adopt a strategy of cooperation rather than competition, as we see from the paragraph that I've shown you in the judgment at paragraph 180, and as the judge found at paragraphs 199 to 200. Why then no consultation? Well, one possible answer might be to say, because Mr Swanty only responded passively. Now, we tested this idea in our skeleton argument by asking whether there would have been consultation if Mr Swanty had responded positively to the invitation to collude. If passivity is the problem, then it should follow that a positive response to an invitation to collude should have given rise to consultation. The defendants' response to that shows in our submission the lack of merit in their position and the difficulty of defending the learned judge's approach. EE, for its part, submits that the thought experiment is self-defeating and misconceived, but notably doesn't give any answer as to whether there would have been consultation if Mr Swanty had taken up actively the invitation to collude rather than merely not objecting to it. So we have a non-answer from EE. O2, for its part, takes the bolder line of insisting that there would have been no collusion even if Mr Swanty had actively taken up Mr Dunn's invitation to collude, and that's paragraphs 11 to 13 of their skeleton argument. Now, the thrust of O2's argument, that even a positive response would not have given rise to consultation, is that Mr Dunn's approach was too vague. If that is right, then there was in fact no invitation to collude, no anti-competitive disclosure, no contact caught by the strict preclusion that we see in Sauca Unia. But that's a rather bold position to adopt, in the light of the fact that Dunn was plainly attempting to initiate collusion between EE and O2. One might think that a sophisticated operator like Mr. Dunn would know how specific an approach he needed to make in order to achieve his objective of sounding out EE on its attitude to cooperation against the indirect retailers, and so de-risking O2's conditional decision to partially exit Phones for You. Put in more general terms, would-be colluders are likely to be good judges of how circumspect they can be when pursuing a reduction in competitive uncertainty, and what they have to spell out in order to achieve their aims and what they require of their competitors. The idea that Mr. Dunn fluffed the approach was indeed O2's case at trial. But the problem with that is that it failed. The judge found that the approach, albeit expressed with some circumspection, was sufficiently clear to be understood and was in fact understood. Could I invite the court to look at paragraph 197 over the judgment? The court will find on page 317. And perhaps we ought to start at 196. I could invite the court to read 196, because that sets out the approach that Mr. Hoskins, then appearing for O2, took in his cross-examination approach. And if we move on to 197, you'll see what the learned judge says. Despite all of that, I don't think that Mr. Swanty fundamentally misunderstood or misinterpreted what Mr. Dunn was saying. And when we drop down a sentence or two, I consider that he was sounding out Mr. Swanty to see whether if O2 reduced its reliance on the indirect channel, he might support that move to preserve value in the market. The fact that Mr. Dunn did not spell this out in clear terms does not, in my judgment, preclude a finding that this was an invitation to collude. There need not be precision or specificity if he was conveying a message which his competitor could understand. So, the learned judge was not persuaded by O2 that Mr. Dunn had failed to get across the thrust of what he was about. And we can see some of the material that the judge relied on in reaching that conclusion back in paragraph 158 of the judgment. On page 307 of the ballot. And that is the email sent by Mr. Blendis to Mr. Swanty on the 25th of October for the purposes of reporting to him, amongst other things, on the meeting with Mr. Dunn. And the important paragraph for present purposes is the second paragraph.
Yeah.
Now, if we could then go back to paragraph 196 of the learned judge's judgment, which I've just shown you, the judge says potential collusion or an attempt at collusion over 4G pricing is not the allegation. Critical question is whether Mr. Dunn indicated to Mrs. Swanty that O2 was contemplating withdraw from one of the main or one or more of the indirect retailers from phones for you, in particular, and sought to gain comfort that this would not lead to the volume of connections from phones for you being taken up by EE. So that's what the judge said is the critical question. And we've already seen paragraph 197 that the message which was being conveyed could be understood by Mr. Swanty. And then if we then turn to paragraph 199 on page 380, we see the rejection by the judge that the approach was too vague to be understood. I should add in cross-examination, Mr. Swanty, Mr. Hoskins suggested that the unilateral steps in the cards could refer to a range of different things. For example, the purchase by O2 of phones from your car phone. No doubt they could, but I find that is not what Mr. Dunn meant at the time. He was, in my judgment, referring to the decision in principle to exit from phones from you, which O2's ex-con had taken a few days earlier. And although Mr. Swanty could not tell to what degree O2 might reduce volume through the indirect channel, and whether that would involve phone, physio or car phone, both, he had correctly understood the thrust of Mr. Dunn's remarks. Now, it's plain that the judge reached in these paragraphs two key conclusions. For paragraph 197, Dunn was sounding out Swanty as to whether if O2 reduced its reliance on indirect channels, EE would support that move. Per 199, Swanty understood the thrust of what was being told, he was being told, and what was being asked of him. Although he did not know what precise steps O2 had in mind, including whether it intended to pull volume from phones or car phone. In our submission, the judge therefore answered the critical question which he posed to himself in 196 in the affirmative. Now, in those circumstances, we submit that it would be hopeless to submit that there was no qualifying invitation to collude, and so nothing that if Swanty had taken up positively would have given rise to consultation. Now, if we submit that is correct, as it must be, then the fact that the disclosure and invitation to collude was conveyed in guarded terms can't be an obstacle to establishing consultation. One turns then to consider whether, and if so, why, the passive response, the invitation, was insufficient. Now, you will see, and will have seen in the submissions put forward by my learned friend Mr. Hoskins, that they rely very strongly on a case called HSBC. I'm going to refer to it as HSBC at the moment, HSBC. But I'm not going to take the court through it. It was a wholly different case from the present, not least because it did not involve any invitation to collude, and the information which was exchanged between the traders on either side of the line wasn't relevant to any contemplated transaction. Neither of the vices in Soca Unia was present. It does not establish any general proposition of law, nor does it provide any general applicable yardstick for assessing how specific an approach must be in order to give rise to consultation. Now, in short, on the judge's findings, Mr. Dunn made an anti-competitive disclosure, proffered an invitation to collude, and any vagueness or generality in the language was not such as to defeat the approach as a matter of law, as a matter of fact. So we must then look for what else it was in the nature of the response and ask why that was insufficient to give rise to consultation. Now, faced with this anti-competitive approach, there were essentially three ways in which Swanty could have responded. First, the disclosure, an invitation to collude, could have been actively rejected, a negative response. On our facts, Mr. Swanty could have said, "No, Ronan, you must stop talking about the confidential plans. EE is not interested in cooperating with you in this." But that did not happen. The disclosure could be actively welcomed, and the invitation to collude warmly embraced, a positive response. On our facts, Mr. Swanty could have said, "Don't worry, Ronan, E is on board with O2's strategic move against indirect retail, and you can trust us to cooperate. The third option is a response that is neither positive nor negative, but sits in the space between a passive response. And that is what the learned judge found was Mr Swanty's reaction to Mr Dunn's approach, judgment 200. Mr Swanty knew full well he was the object of an anti-competitive disclosure and invitation to collude. He was, as your lordship has noted, sufficiently concerned to start recording the conversation on his iPad and to later play the recording to E's general counsel, who made a transcript of it. But he uttered not a word of objection. On the judge's findings, he was perfectly passive. If Mr Swanty had chosen option 1 and given a negative response, it's common ground that would prevent consultation from arising. E argued at trial that Mr Swanty had in fact responded negatively and rejected Mr Dunn's approach, distancing EE from the attempted collusion, but the learned judge rejected that argument. And the reference for that is in paragraphs J220 to 224. And perhaps we can just look, if we may, at judgment 224. On page 326. And your lordships and your ladyship will see that one of the arguments which was run that Mr Swanty's body language at the lunch had been sufficient to indicate to Mr Dunn that he wasn't interested in coordination. And the court will see that, that the learned judge rejected that, but that just indicates the sort of problem that one would get. Would it be enough for Mr Swanty to have raised an eyebrow rather in the way in which Roger Moore had done? Would that be enough? The fact is...
Is that a reference to his performance as the saint? Or as James?
Well, indeed, my lord.
Or both?
Well, indeed. Indeed, that's the problem with putting forward a concept such as body language as a rejection of an approach.
Well, the judge rejects that.
He does. He does.
He says it's unworkable.
Wholly unworkable, but it does. It is going to show the problems that if a passive response is not enough, as we say it is, a passive response on the authorities is plainly enough when you're faced with an invitation to collude.
Yeah.
Is, as EE's case requires there to be, are there two kinds of silence? A silence which conveys positive support, or a silence which conveys rejection. And for good reason, the law says, no, if you are going to object to an approach like this, you better do it properly and expressly, not by body language or anything like that. Now, positive responses and passive responses have in common that each is capable of giving rise to consultation. And we rather agree with what the CMA says about this. If we could look at paragraph 35 of their skeleton argument, page 992 of the core bundle at tab 27. Under the heading Additional Requirements for Finding of Consultation, the first is said that the need to demonstrate positive support or an agreement to cooperate. This putative requirement is said to derive from the judgment setting out the reasons.
So, which paragraph you in?
Forgive me, my lord. 35. Towards the bottom of the page.
Yep.
The CME agrees that any such requirement would be wrong as a matter of law, sufficient to show that an undertaking participated in meetings or other contacts in which commercially sensitive information is disclosed without publicly distancing itself from such an unlawful initiative. And there's a reference there in the footnotes to JJB Sports against the OFT, and I wonder if we could just briefly turn up that case. It's in the Authorities Bundle, Volume 2, Tab 7, at 10, at page 394 to 395. And the bit I want to show the court is towards the bottom of the page. Scroll down at 1043 and over to 1044. But I'll wait till, if you could wait until the court gets there, please.
Sorry, page number?
Page 394, my lady, and paragraph 1043. It is thus plain an undertaking may be passively part in an infringement, that is so in particular where it has taken part in a meeting or other contacts and has done nothing, keep going, to distance itself from the matters discussed. In those circumstances, the undertaking is taken to have tacitly approved of the unlawful initiative, unless it has publicly distanced itself or informed the OFT. And then an important sentence, my lords and my lady. In our view, that principle is extremely important as far as the enforcement of the Act is concerned. Now, competition law might have taken the approach that only the expression of positive support for an anti-competitive proposal, whether given vocally or tacitly, was sufficient to give rise to consultation. If the law had gone down that route, one might have to ask whether on given specific facts, passivity would convey positive support. But that's not how Article 101 is interpreted and applied, and for very good reason. Passive responses are taken, or is treated as, amounting to tacit approval. It's not a question of whether passivity was on the specific facts sufficient to amount to positive support. Treating passivity as providing tacit support is crucial to the effective enforcement of the prohibition. So in our respectful submission, positive and passive responses to an anti-competitive approach and an invitation to collude both appear on the other and wrong side of the line from negative responses. They're inconsistent with genuinely independent conduct, and they are capable of materially reducing competitive uncertainty. And
Sorry, did you say capable?
yes,
Isn't there ultimately a requirement that there is a reduction of uncertainty?
no, there is an object and effects approach.
So even if, on your case, even if Mr. Dunn in fact could gain nothing from silence, or did gain nothing from silence, no hint that EE would not go and hoover up the indirect market if O2 got out, that would still be sufficient on your case?
Yeah. On a strict reading of the Act, yes, it would. But we don't need that because we've got the judge's determination, paragraph J225, that he did in fact take comfort.
Yeah, that's why I asked you the question I asked you.
Yes, J225 is an express finding.
225, isn't it?
So that would be the natural inference in any event, whether the judge had actually found that. It would be the natural inference, consistent with the case law. If you turn up and say, how about a bit of collusion, and you don't say, no, not on your life, the tacit response conveys approval, qui tacet consentire videtur, use a bit of Latin. That's how the law approaches this. But we have the
So this is where he's looking at the alternative case. His conclusion is actually 208.
Let me just look at that, my lord. Yes, you're looking there at the position of EE.
At 225, he's looking at
The position of
the
O2.
position of O2, isn't
Yes,
he?
exactly. So I'm going to come on to the two reasons as summarised in Judgment 217 as to why this didn't amount to consultation. The last sentence of 217 explains that. And he says in 217 it wasn't sufficient to benefit EE. That's one point. And the second point, he says it didn't convey a consensus to cooperate. And I'm going to deal with that as well. But my point at the moment...
As my lord says, he is dealing at 225. This part of his judgment is dealing with public distancing.
Yes, he is.
It's not dealing with...
He is. But nevertheless, it's a finding as to the impression that Mr Dunn was left with as a result of the meeting.
Well, we'll no doubt come back to this. You've got to try and work out what the judge meant there by objecting or wholly uninterested, and whether those statements are in the context, as my lord says, of this being a part of the judgment dealing with public distance.
It is. But nevertheless...
If you make an anti-competitive approach to me and you say, well, actually, this is what we're planning to do, that's effectively you're done and
Yes.
I'm Swansea,
Yeah.
and I sit there, I'm not wholly uninterested because I haven't covered my ears
Yes.
or walked away.
Yeah.
But I may give you absolutely no clue about what your disclosure to me might mean about EE's future behaviour, and that's the bit you need to get to.
No, with respect, no. Because the law is perfectly clear that the mere fact of disclosure of your plans or contemplated actions, you've seen this in South Africa, from one competitor to another, is an object infringement.
Well, the second sentence of 225, you would say, it's obviously put the other way around, but what that's effectively saying is that Mr Dunn took from Mr Swansea's passivity that he wasn't clearly opposed to any kind of anti-competitive exchange.
Correct.
Because otherwise he wouldn't have tried to sort of made another collusive approach subsequently, let alone what he said or what was said in the email exchange at the beginning of January.
Yes.
So you say that's an indication, or it's a finding by the judge,
Yes.
that Dunn was comforted by Swansea's passivity.
He gets non-opposition.
Yeah.
What Swansea should have done, and the only proper approach would have been to say, you have a red light. That is the only proper approach. And his non-opposition fell on the wrong side of the line in accordance with the authorities. Quite clear from JJD that silence...
You say the error is apparent then in paragraph 217.
Yes.
The last sentence.
I do. I'm coming to that, my lords. I'm coming to dissect 217, because that effectively summarises why, from the perspective of O2, he doesn't take anything from this, despite the fact we already got the non-opposition.
Where I think it's difficult is that 224, 225 is all coming in the section where he's considering if he's wrong as to whether there's consultation. So he's already contrary to his finding, was now considering, well, what do I take if there was a consultation? Was there public distance?
Yes, he is. But when one comes to look at 217, we'll see that that isn't inconsistent with what I'm submitting now about 225. Because what he seems to want to require with 2217 is that there be any form of acquiescence or consensus to cooperate. Now, what does that mean? And I'm going to address you what that means, because the judge has given us a helpful indication in his judgment refusing permission as to what that means. And what the judge has required there, apparently, goes beyond the authorities, which make very clear that the tacit acquiescence, the tacit receipt, passive receipt of an anti-competitive approach conveys either a green light or it conveys non-opposition, which is sufficient for the distortion of competition.
Well, what I understood the judge is really saying in the earlier paragraphs is that this is also vague. That Mr Dunn wasn't conveying anything that EE could take anything from, and therefore he also couldn't take anything from from the non-reaction of EE.
Well, that's a bit strange, my lord, given that we know from looking at paragraphs 197 to 199 that a message had been conveyed in terms which was understood by the recipient. He understood the thrust of the message. Now, when Swanty sits there, having understood the message which is being conveyed, Dunn is on the other side of the table. Yeah. Dunn is a sophisticated person. If Mr Swanty doesn't understand what is being said, he says so. So Dunn, sitting on the underside of the table, can be satisfied that the message which he has conveyed has been understood. And indeed the judge finds that the message, the thrust of the message, was understood. So what Mr Dunn gets from this unlawful and collusive exchange is that Swanty Swanty has received the information, and Swanty is not averse to adopting a cooperative approach to dealing with the dealing with phones for you.
That's the piece. That's the piece I'm. So there's a bit of a jump in what you just said that I'm struggling with at the moment. There are the passivity could convey various things, and obviously would convey various things in different contexts. Quite obviously, sitting there in a meeting of several competitors discussing price fixing, and you sit there quietly, might well convey that you're going along with what's being done. In this case, one potential thing that it conveys is just, I hear what you say. I'm not standing up now and saying I'll never receive an anti-competitive approach. But it doesn't go on to convey anything from which Mr Dunn can gain comfort about future market conduct. Don't you need to make that jump?
No. In the situation that we have here, this is a very different situation from a bystander at a meeting where bad things are being talked about. It's quite clear, the law is quite clear, that even if you do not participate in that meeting, participate in expressly contributing consent or approval or anything like that in a meeting, it's not good enough for you to say, oh well, I didn't participate. The law finds that you are liable. We can look at the authorities that say.
The difficulty, I suppose, might be said to be that the last sentence of 197 and the last sentence of 217 are inconsistent with each other, and 225 is inconsistent with those
as well.
Yeah.
Um,
That's why we have to go back.
Consistent findings.
That's why we have to go back to first principles.
Yeah.
And what I'm submitting is that in first principles, it is plain that an understood anti-competitive approach, which is not rejected, is sufficient to give rise to consultation. All we're talking about at the moment is the first element of a concerted practice, namely consultation.
And that Mr. Swanty did understand it to be an anti-competitive approach is really demonstrated by his subsequent conduct.
He did.
Because if he hadn't been worried about it, he wouldn't have bothered talking to Mr. Blandis.
Indeed.
But effectively, it's the first thing he does.
Yes. My point is that, as a matter of law, non-opposition to an approach like this, which is understood, is sufficient to create consultation. Now, the learned judge's judgment in paragraph 217 seems to suggest that non-opposition is not enough, and we submit that that is wrong as a matter of law. But he is not accepting 217 that non-opposition, which is obvious was the case, he says that's not enough. And I'm going to
Well, he's saying that the silence, passivity, must be such from which the disclosure could infer acquiescence or that seems to be the
yes,
step further than you would allow.
yes, absolutely. No. In our skeleton, we deal with 217 and what appear to be two features of his reasoning in 217. Namely, with too vague to remove uncertainty in EE as to O2's future conduct, and the circumstances were such that Dunn couldn't have inferred from the silence any form of acquiescence or a consensus to cooperate. Now, in our submission, the first point is this, that non-opposition, silence is likely to convey non-opposition. In circumstances where a collusive approach made and understood should receive a red card. There's no question but that is the appropriate approach when faced with such a collusive approach. Now, in our submission, and following what my Lord the Chancellor said, the judge indeed found in 225 that the passive response conveyed non-opposition to Mr. Dunn. So, if Dunn was left with the impression that E was neither objecting nor wholly uninterested in these anti-competitive approach, that is sufficient to give rise to consultation. And if we look at what the learned judge said in his grounds for refusing permission to appeal,
Yeah.
this is at tab 19, the bundle, at page 469. So, paragraph 22. So, he says that if you take away the negative, that Dunn was given the impression Swanty was not objecting or wholly uninterested. He says that's consistent with the finding that he did not think Swanty was positively supporting the course of action that O2 wished to pursue, or that his silence implied an agreement to cooperate. So that gives colour to what it was that the judge was saying in 2.
You say that last sentence of 22 misstates
The law,
The
yes. And we have
overstates it. Overstates the
overstates it, my lord, yes. And we have the support of the CMA in that. They say that we look at core bundle 27. Yeah, it's the paragraph I've shown you already on page 992, paragraph 35. First is said to be the need to demonstrate positive support for an agreement to cooperate. This putative requirement is said to derive from the judgment, setting out the reasons for refusing permission to appeal. CMA agrees. Any such requirement would be wrong as a matter of law. So, Mr. Dunn's approach was totally inconsistent with genuinely independent conduct. And that is the guiding principle that runs through all of the cases. And what Swante's passive response conveyed is non-opposition. And that non-opposition is sufficient to give rise at this stage to consultation. He knows that EE is not actively opposed to strategic action or hostile to the idea that it might wish to cooperate with O2 rather than taking tactical or strategic advantage. That was not nothing. It resulted in a material reduction in competitive uncertainty and a distortion of competition. Now, the cases sometimes refer to removal or reducing competitive uncertainty, seemingly as alternatives. It's obvious that the reduction in competitive uncertainty is sufficient, and the CMA again agrees with us that an anti-competitive disclosure must reduce but need not remove competitive uncertainty. That's paragraph 32 of its skeleton argument at page 991.
Yeah.
That does say reduce uncertainty, not capable.
Well, it has to be capable of reducing uncertainty.
There must be some reduction of uncertainty.
Yeah.
We can answer that by looking at the case I haven't taken to you yet. That's the case of Nichicon, volume 13, tab 54, page 386, 3086.
Yeah.
What I'm interested in.
Sorry, which tab again?
Sorry, my lady, tab 54.
54.
Page 3086. And if you turn into internal 3120,
This is a decision of the General Court.
yes, it is.
So page
3120. And if you see at paragraph 105 and 106, we see the well-trodden, well-understood principles from Sauka Unye about independence. And then if I may ask the court to read to itself paragraphs 107 to 112.
Yeah.
So, what we have here is a meeting where information has been conveyed, which is inconsistent with true independence, and it is capable of creating conditions of competition which do not correspond to the normal conditions of the market. Mr. Dunn, let's go back to stage one. Mr. Dunn was coming to see Mr. Swanty because a week beforehand, a provisional decision had been taken by O2 to exit from Phones for You, which was a risky decision for O2 to take by reason, amongst other things, the prisoner's dilemma, which I mentioned in the beginning. And he came with the object of de-risking that, as the judge held. He conveyed the message, and the message he got back was that, from the silence of Mr. Dunn, that EE was not opposed to cooperative behaviour, and he should never have received that information. EE should have raised the red card at that stage.
Forgive me, but what I keep coming back to, and it seems to be the key point that the judge was ultimately deciding the matter on, was the vagueness of the information, and which he starts considering at 205. The information must be sufficiently clear to put the recipient in a favourable position, and that then seems to be picked up in 208. My understanding of overall what he's saying is, yes, Mr. Dunn intended to collude.
Yes.
And once he understood that, effectively Mr. Dunn failed.
Well,
because what he conveyed was too vague to either enable Mr. Swanty to take an advantage, or for Mr. Dunn to draw anything from Mr. Swanty's passivity.
but the problem, my lord, about that is when you look at 217, you'll see that what the judge was expecting or saying that had to be taken from the passivity was an agreement to cooperate or positive support, and that's simply wrong as a matter of law. And the CMA agrees with us on that. So you've got an anti-competitive approach, which is not so vague that it cannot be understood by Mr. Swanty. And in those circumstances, Mr. Dunn comes away from the meeting, not with a positive embrace of the approach, but he comes away from the meeting knowing that EE is not adverse to cooperating in actions against the indirects.
Well, that's 225.
Yes.
And that's why the significance there is really, as I suggested to you, the second sentence, which is because Dunn comes back with more.
Yes.
Some weeks later.
Yeah,
if he'd really thought that Mr. Swanty's was opposed, or just not in the slightest bit interested in anti-competitive behaviour, he would hardly have come back.
Correct. And that's one of the vices of a failure to repudiate an anti-competitive approach that the case law refers to. It encourages further anti-competitive behaviour, as we see in this case. It did, just a matter of weeks later.
Well, the JGB Sports, which you referred us to,
Yeah.
what's said in whichever paragraph it is in that case,
1043,
follows on from quite a lengthy citation of the Ardball Portland Cement case.
Yes.
Which is a European court decision to like effect, isn't it?
Yes. No, those cases were different in this sense.
Well, they were different in the sense there were a load of people at the meeting.
Yes. Indeed.
It's like the classic old-fashioned. I can't remember whether it was the tyre manufacturers' conference or the cement manufacturers' conference, whatever it was, back in the days when it was called restrictive practices.
Yes.
Who basically it was just nod and wink stuff.
Yeah.
I can't remember whether they met in a pub or
Smoke-filled
whatever
rooms
it was.
in those
Nobody
days.
ever actually said anything.
No.
But they all went away knowing what the other ones meant.
Yeah, nod and a wink will do. That's why body language doesn't help either. But ultimately, the judge has imposed in 217 too high a hurdle to get to the stage of consultation, as we see, and he was wrong as a matter of law in relation to that. Insofar as there is vagueness, that relates to the benefit to EE. Now, as we've seen, there are two elements in 217. It didn't remove uncertainty in EE as to O's conduct. But what it conveyed, what the passivity conveyed to Mr. Dunn was non-opposition. Now,
I suppose I'm struggling with non-oppositional in what sense?
non-opposition in the sense that it's not been repudiated, which is what ought to be the case. If we go back to first principles, strict preclusion against contacts between undertakings, whereas the object to influence the conduct of the competitor on the market. Swansea understood that in this case. It was the object of affecting Swansea's behaviour on the market because he was being invited.
Yes, but you're not pursuing it in that
I
direction.
understand.
You're pursuing it in the other direction.
Yes, and that non-opposition conveys back useful information to the competitor.
But just humour me. What useful information? Because if I'm Mr. Dunn and Mr. Swansea is sitting there silent, yeah, I might deduce that he's not saying no, you mustn't make any anti-competitive approaches. But as to his let's take the language of 225, not wholly uninterested. There's at least two ways one might have understood that if you're Mr. Dunn. One way you might understand it is he might be interested because he'd like then to sign a better deal with Phones for You himself. And in other words, take up that indirect capacity. Another might be the one you're arguing for.
Well,
but why is it the one that you're arguing for? Or is that we just have to assume that because that's the effect of the cases? Is that what you say?
I'd say a number of things. First of all, as far as the case law is concerned, if a recipient receives an anti-competitive approach, his silence, non-rebuttal, constitutes tacit approval of the approach. That's what the case law.
Tacit approval of the proposed anti-competitive
Exactly.
conduct.
Exactly. Now,
so does that mean that the answer to my latest question? Because I think that I think just about to ask you the same or a similar point.
yes,
That none of that matters.
exactly. There is.
So I mean, because one way of looking at it is that Mr. Dunn might have thought from Mr. Swansea's silence that Mr. Swansea was taking in, understood perfectly well what he was talking about was O2 exiting from Phones for You, and was thinking to himself, well, that's a jolly good idea because we'll take up all that business when they've gone, which was been rather self-defeating from Mr. Dunn's point of view.
Well, why
Does that? I mean, the judge hasn't made any findings about that at all.
No, he hasn't. And that's why I say an approach like this, which is met with a passive response, gives rise to consultation as a matter of law. And furthermore, when we look at J225, we go back to J225, we find that there is a degree of encouragement that Mr. Dunn derives from this, because if he wasn't encouraged, he wouldn't be back for more. Yeah. Yeah. Well, if he had felt that Mr. Swampy was clearly opposed to any kind of anti-competitive exchange, Mr. Dunn would hardly have called him some weeks later. So what Mr. Dunn derives from this is that this approach, Mr. Swampy, is not clearly imposed.
Yeah.
So he's going to go, and that is not nothing. That is information which a competitor should not have.
But I think what the judge is saying is not clearly opposed to what? Because it's all too vague for it.
Cooperation. Cooperation.
Cooperation in what?
Cooperation in dealing with the problem posed by indirects. Yeah. And if we look at the last sentence of 225, we see that Mr. Dunn's behaviour, the judge says, would also be inconsistent with Mr. Evans's text message to Dunn of the 2nd of January 2013, suggesting they should reassure Mr. Swampy as part of strengthening the resolve against the indirects. So, strengthening the resolve, what you get from an anti-competitive approach like this, which Mr. Swampy understands, he may not know precisely what steps you're going to take, but you derive the impression that there is a resolve against the indirects. Now, that is information which is valuable to a competitor in terms of judging what the response of the competitor may be to your actions in the market, and it reduces the uncertainty to which Mr. Dunn and O2 were exposed prior to this approach to Mr. Dunn.
Yeah.
And in that sense, you have ruled out outright hostility to cooperation against the indirects. And outright hostility is what should have been derived if Mr. Swampy was behaving properly in accordance with Article 101 and the UK analogue. Now, as far as we are aware, there is no other case in which it has been concluded that a passive response to an invitation to collude or an anti-competitive disclosure made in the course of an anti-competitive meeting was insufficient to give rise to consultation. It doesn't appear to be such a case, and we say for good reason.
And if we go back to, well, it's a point you've already put to us, I think, but go back to 225.
Yes, Madam.
And what's said there, which you say is, if the right test had been applied, then that should have been sufficient.
Yes.
And the judges,
From the perspective of Mr. Dunn.
from a perspective, assuming that for present purposes that the certainty or the comfort or whatever it is gives Mr. Dunn is sufficient.
Yes.
The judge deals with this in his permission judgment, as you showed,
Yep.
by saying, oh, well, that's not sufficient because you need to have either positive supporting the course of action or silence implying an agreement to cooperate.
Yeah, and that's wrong as a matter of law.
Just overstates the test.
Yes. I mean, one way of looking at this is he reconciles 217 and 225 in the way in which he does in the permission judgment, but in so doing, following my Lord the Chancellor, he overstates the position, and on our submission makes an error of law. Now,
In the permission judgment.
well, the permission judgment explains in our submission properly what he was saying in 217, and that's an error of law. Now,
Well, he's explaining how you reconcile 217 and 225.
yeah, and if you reconcile it that way, as he seems to, that's wrong. Now, I haven't discussed with the court whether the court wants to take any break for the shorthand writer.
No, I'm sorry. I did actually, at the beginning of the day, contemplate saying to you that maybe we should have a break around about 11:30, but it didn't seem a convenient moment because you were in quite a sort of dense bit of your argument.
Yes.
Would it be sensible? We don't want to take too long, so
No,
if we said on that clock, if we could be back by 10 past.
My lord, yes. I'm not seeking. I'm very happy to continue, but
No, I think it would be sensible.
All right, so thank you. Just to remind me, call out the light.
what am I going now? No. Yes. Well, that's
That's all right.
we'll consider back. I'm going outside.
Yeah, I'm getting it.
I think that's 2 minutes behind.
Okay, well, that's fine.
think so, because there'll be less.
Have we aged well?
Yeah.
Did you drive a Porsche?
No, that's true. No, I thought so.
Well, I used the upgraded one first, but it's more everything is through. Oh yeah, that's right. This is the reason I bought the last car, because I could actually fit it. Yeah, it is. The boot is like that. So it's stupid.
You only take it.
Already selling it. You and wife.
My lord, my lady, although I'm not going to go to it, can I give you the reference to some case law in our supplementary skeleton, footnote 9, call bundle, tab 9, page 209. And that is a number of authorities for the proposition that the judge can use the permission judgment to elucidate points which are already in the main judgment, which is what learned judge was doing in paragraph 22. The permission judgment.
Well, if the judge is explaining what appears to be an inconsistency,
Exactly.
and why he reaches the conclusion,
Yes.
then the court's entitled to take into account that
Yes.
explanation
Yeah.
in determining whether or not the judge has erred in law
Exactly.
or in
Yeah.
time.
Exactly. I was going to turn now to address the court on the Atura's case, which the judge seems to have placed some reliance on in rejecting our case. And you will find that in Authorities Bundle 12, tab 51.
This is Atura's, is it? I don't think the transcriber picked that up.
ETURAS, Atura's.
Yeah. Okay, sorry, what reference?
That is Vol 12, 51, 2978. And the judge refers to this in 214 to 215 of his judgment. Now, the short point about Atura's, before I come to look at the relevant paragraphs in it, is that the learned judge himself noticed that Atura's is a very different kind of case from the present. It was actually a case about a unilateral communication sent in a e-messaging system. It did not involve a face-to-face meeting between competitors. So the most notable feature of the facts in the case was that the message was notified to participating travel agents of the unlawful cap on discounts, sent to an inbox which the travel agents may or may not have accessed. There wasn't necessarily any relevant contact between the party proposing a collusive scheme and the supposed participants. It was thus far removed from a face-to-face meeting in what we have in this case. The situation at issue in Iturus, silence or passivity from a travel agent, may simply have meant that the message had never been received and never been read. And it's that crucial fact that makes sense of the paragraphs cited by the learned judge in his judgment. If we turn to page 2990, and we see in the opinion of the Advocate General, paragraph 44, it says the court has not yet had the opportunity to clarify the circumstances under which unilateral communication may result in a concerted practice between the addressees and the sender. As I said, we're not talking about face-to-face meeting, which in a smoke-filled room or a landmark hotel, which is the normal situation. 45, according to the settled case law of the General Court, the concept of concerted practice does imply the existence of reciprocal contacts. The conditions met where one competitor discloses its future intentions of conduct on the market to another, when the latter requests it, or at the very least accepts it. The concept of a concerted practice does imply reciprocity. Concerted action is necessarily the result of consensus. However, the level of formalisation of that consensus should not be subject to overly rigid requirements, and this would undermine the versatility inherent in the concept of concerted practice. In particular, reciprocity should equally encompass tacit approval. However, the possibility of inferring tacit approval and therefore of establishing the existence of a consensus to cooperate rather than compete depends on the context of the communication. First, where an undertaking receives information relating to an illicit initiative and does not oppose it, its acquiescence in that initiative may be inferred from the absence of a response, provided the circumstances are propitious to the formation of a tacit consensus. The lack of opposition to an illicit communication is reprehensible, because under certain circumstances, the mere lack of reaction from the addressee will lead the other party or parties to believe that the addressee subscribes to the illicit initiative and will comply with it. Therefore, in order to infer knowing participation of the addressee in a concerted practice, the context of interaction must be such that the addressee may be deemed to appreciate the competitor will consider its silence as an approval and will rely on mutual action even in the absence of a response. Now, as I've said, this case was not concerned with a face-to-face meeting between competitors. The context of the interaction, which the learned Advocate General is referring to in this case, is messages sent by an administrator and popping up in an inbox where it's not possible to know whether the message has been received, understood, and acted upon. In our case, we know very well that the context of the interaction was between two of the most senior individuals in EE and O2 at a lunch meeting where Mr. Dunn's approach was conveyed to Mr. Swanty orally. Mr. Swanty understood the thrust of what was being said to him. So it's a million miles away from the circumstances of the Iturus, which the learned judge seems to have relied heavily on in deciding the case against Phones for You. Now, the words that the Advocate General used in these passages that I've read to you are not reflected in the reasoning of the court. The court applied a simpler approach by focusing on whether there was sufficient evidence that the travel agencies had been aware of the content of the message that had been sent to them. And we can see that if we turn to page 3005, 2005, of the CJAU's judgment. And I wonder if I could invite the court to read paragraphs 43 to 45 to yourselves. Now, in paragraph 217 of the judgment, the judge said that the circumstances of the isolated discussion between Mr Dunn and Mr Swanty were, as he put it, far removed from the situation in accuracy. Well, we agree with that, but he seems to have thought that this told against a finding of consultation in this case. But in our submission, the Churis situation was far removed from the present case. In the present case, the landmark lunch was a paradigm of the type of case of direct contact between competitors strictly precluded by the law. The Churis was obviously completely different. In our case, there was no question that Mr Swanty was aware of, as the question was in the Churis, are you aware of the message? He was aware of Mr Dunn's invitation to collude. EE was at the very least in an analogous position to the those travel agents who were aware and had read the message carried on the system. I'm going to come back to the Churis.
Well, that's the point. That is an important point as well. There's an issue in the Churis about awareness, but if they were aware and didn't actively object, they knew that because of the way the system worked, they would have known that the discounts would count.
Yes, that's right. That is a fact.
So it does follow through into actual action.
It does, but absolutely. But the point I'm simply making is that the way the judge appears to have relied on the Churis to find against phones for your consultation isn't supported by that case. And it doesn't set up an additional hurdle for showing that a passive response where a meeting takes place is insufficient to give rise to consultation. Now, EE's answer to whether a passive response or non-objection suffices to give rise to collusion is that it depends. As it's said to be fact sensitive. And that seems to chime with the judge's reasoning that there was no consultation because the invitation to collude didn't meet with positive support and agreement, merely non-opposition. And applying that approach, it would follow that a passive response only gives rise to consultation where it can, on the specific facts, be equated with positive support. But the problem with an approach which says it depends is, one, it's not supported by any authority, and it immediately leads to the question, depends on what? EE has not identified any principled basis to distinguish between cases in which a passive response is sufficient to give rise to consultation and one where it is not. And as I said earlier on, dividing passive responses into two categories, one which gives rise to consultation and one which does not, is hardly conducive to legal certainty. And I showed the court some time ago what the fact had to say in connection in the JJB case. How are we to distinguish a silence which conveys positive support and one which conveys merely non-opposition? That would lead to an evidentiary quagmire, and furthermore, how would a putative victim of collusion decide whether to bring a case where there had been a passive response to an invitation to collude, but where it might be found ultimately that it couldn't give rise to consultation because it was the wrong kind of passive response? That, in our submission, is not consistent with the strict principle of independence, and it's not consistent with legal certainty.
But if just looking at what's said by the court in Etruris,
yes,
you would say 45 is obviously the judgment of 3005.
yes,
Is making the point that if if it cannot be established that the travel agency in question actually received the message
Yeah.
and read the message,
Yes.
then that its participation in a consultation cannot be inferred.
Correct.
But 44 says that travel agencies which were aware of the content of the message at issue could be regarded as having tacitly assented to a common anti-competitive practice, provided the other two elements
Yes.
of which are necessary.
Exactly. And then the other two elements.
Anic and
Exactly.
yeah.
Exactly.
So I mean that seems to support the and that's consistent. If we go back to the Advocate General, the Advocate General at 49
Yeah, it is.
refers in a footnote to Arbour Portland Cement again,
Yes. Correct.
which is the case that JGV supports.
Yes, indeed. So there is consistency throughout the authorities, and a consistency which, in our submission, the approach of the learned judge failed to apply. Now, I want to turn to the second of the reasons that the learned judge gave in paragraph 217. I've been really rather talking about consensus to cooperate and why we say the judge put that bar too high. Benefit to EE. Our point there is, as I started off in my submission, my lady picked me up, we find it to be a little surprising what the judge said about absence of benefit to EE in the light of his findings in 197 and 199. But leaving that to one side, we say he was wrong to focus simply on the benefit to EE. Unduly restricts, if you do that, it unduly restricts the scope of the strict preclusion between contact between competitors. It reduces competitive uncertainty. And I submit that the CMA understands, supports the proposition. If we look at what they have said at page 994 of the core bundle, tab 27, paragraph 40, my lord. As to the second limb, the CMA submits that any requirement for a finding of consultation to consider only the effect of a disclosure of information on the recipient would be wrong as a matter of law. It's well established that a concerted practice precludes contacts between competitors that could influence conduct on the market or disclose one's future conduct. So there are two limbs to this. Let's not forget that Mr. Dunn had a purpose in doing what he did. He wanted to de-risk a provisional decision. He went and sat down with one of his close competitors. He came away with from the meeting without a red flag, and a matter of weeks later, they followed through on the provisional decision they had taken. In our submission, that supports the proposition that what Mr. Dunn derived from this was at least valuable information which enabled them to to de-risk the decision that they had taken. Now, as to how the disclosing party benefits from a passive response.
Sorry, I can see that one approach says the judge could have found that Mr. Dunn got what he wanted from the lunch.
Sorry, my lady.
One approach would be to say, well, the judge could have found, as a matter of fact, that Mr. Dunn did get what he wanted from the lunch. He got something that helped de-risk the provisional decision they've taken. But really, I'm still trying to understand whether you're saying that, as a matter of law, the judge had to conclude that he got something.
Because there was, what was required was an objection. His receipt of the information, his passive receipt of the information is treated as a tacit approval. As a matter of law.
As a matter of law, and that's the end of it.
It is
Even if Mr Dunn, in fact, came away none the wiser.
even if. It's contrary to the strict preclusion contacts between competitors. Now, but if we think about what a disclosing party gets from a passive response, at least ordinarily, a non-objection will convey information to the discloser. You get the comfort of non-opposition, which results in a reduction in competitive uncertainty, which is inconsistent with genuinely independent conduct on the market. And if we look at what the CMA say about this, on back to Core Bundle 2, tab 27, page 997. Paragraph 53. Now, we're referring there to the application of the Anic presumption. But you don't get to the Anic presumption unless, in the first place, there's been consultation. And the second sentence, if a discloser receives competitively sensitive information from the recipient, i.e. the recipient communicates a tacit acquiescence to an anti-competitive goal or conduct, the Anic presumption applies. That's what we've got here. Now, of course, there is a reluctance in the court to say always or never to circumstances in which a non-objection to an invitation to collude at a face-to-face meeting would not convey information to the discloser. We submit that that is an unlikely scenario. A passive response conveys a potentially valuable insight into the attitude of the recipient, both to the disclosed information and the fact of the illicit disclosure itself. Even if, as I say, we did not have the benefit of the judge's findings in J225, the natural inference would have been that Dunn took comfort in the fact that his anti-competitive disclosure did not receive, as it should have done, the red light. Silence or passivity is at least an indication of some inclination towards cooperation over competition. And as I've already submitted, we know that Mr. Dunn was sufficiently encouraged by the failure to object that he pursued a yet further attempt to conclude in the weeks following. And that shows one of the vices of not manifestly opposing a disclosure such as we have in this case, because it encourages further anti-competitive behaviour. Now, there's nothing unduly harsh in our submission about finding that Mr. Swanty's passive response gave rise to consultation. In our submission, it's important to be a little worldly wise when it comes to considering what happened at that meeting, whether EE has any real claim to sympathy. The two executives were not junior employees. They were the chief executive officers of two major undertakings and two of the three players in an oligopoly. They chose to participate in a face-to-face meeting without taking the sensible caution required by their competition compliance policies of agreeing an agenda in advance and sticking to it. Dunn, as we know, came to the meeting intending to make one or more collusive approaches to Swanty. He made his first approach in relation to 4G pricing, according to the documents, received, astonishingly, no red light, and so proceeded with another closely connected collusive proposal, this time in relation to indirect supplies to the retailers. All Swanty had to do to forestall consultation was to unequivocally object. And if he had done that, there would have been no consultation. Having instead heard Dunn venture into forbidden territory, he set his iPad to record in anticipation of yet further forbidden topics. And that's exactly what happened. Even once Mr. Swanty had failed to object at the lunch, he had a further opportunity down the line to send a letter or some other obvious communication rejecting the approach, so-called public distancing. But that's something that he chose not to do. And we can see why he chose not to do that from the judgment at 227, page 327 of Core Bundle 1, tab 18. The learned judge says this: indeed, it became clear to me on the evidence that Mr. Swanty's primary concern at the time was to do nothing which might disturb the forthcoming launch of EE's 4G offering, and therefore to avoid any action which might have escalated the situation and risked antagonising Mr. Dunn. And if we turn over to page 328, paragraph 229, while I consider that Mr. Swanty was genuinely shocked by what Mr. Dunn was saying and absolutely opposed to any competitive advance or approach from the two, I conclude that he was careful not to communicate that directly to O2 or to escalate the situation out of concern that it may sour their already strained relations at a time when he was concerned not to antagonise them. So, EE, in short, took a risk. And that risk matured into a claim a matter of years later. And any sympathy that one might have for EE for becoming wrapped up in collusion with O2 doesn't provide any basis for watering down the strict requirement precluding contacts of this kind between competitors. We submit the judge's two requirements in 217 can't be squared with the Article 101 strict preclusion. And as to the other elements, the learned judge accepted there was subsequent market conduct, which could, in principle, be linked to consultation. So the second element is justified. And so I now need to address the third element, the relationship of cause and effect between ground 1 and ground 2, to which I now turn. In our submission, the judge's treatment of the consequences of consultation, if there was consultation, and in particular the scope and effect of the so-called Anic presumption, which links consultation to market conduct, was erred in a number of respects. First of all, his treatment involved the following material errors of law. First of all, he wrongly held the Anic presumption did not apply to the conduct of both participants in the consultation, but only to the participant, EE, who received the anti-competitive approach. Second, he should have held that the only means of rebutting the presumption of a causal connection between consultation and an anti-competitive meeting and conduct of participating undertakings was by public distancing. And instead, although in his judgment he gave no reasons for rejecting phones for use submissions to that effect made at trial, he found EE to have rebutted the presumption despite the absence of public listening. Third, even if it were permissible to rebut the presumed causal connection by means other than public listening, in our submission, the judge failed to apply the exacting requirements for the nature of the evidence by which participants might do so under EU and domestic law. And fourth, the learned judge's analysis of the common law causation issue both ignored the effect of the Anic presumption and continued to assume, as per his analysis of consultation, that would involve and require a quasi-agreement or at least an expression of positive support. Now, consultation, forgive me, a concerted practice being ultimately a single legal concept, it's perhaps not surprising in our submission that if the judge misapplied and misunderstood what is required for consultation, that error flowed through into his treatment of the other issues. Now, it is common ground that there is a legal presumption that satisfies the third element, the relationship of cause and effect between consultation and subsequent market conduct. And this is called the Anic presumption because it derives from paragraph 121 of the CJU's judgment in the case of the Commission versus Anic. I don't think we need to take it up, but for the court's note is at volume 9, tab 36, page 2158. And indeed, the learned judge cited Anic at paragraph 79 of his judgment. Now, as I've said, we submit that the Anic presumption applies to the conduct of all undertakings that participate in consultation, either actively by providing an anti-competitive disclosure or making an anti-competitive invitation to collude, or passively by accepting the disclosure or not objecting to the invitation. The learned judge rejected that submission, holding that if there was consultation, the Anic presumption only applied to EE's conduct, not also that of O2. You'll note that's at paragraphs 231 and 232 of the judgment. And as I said, our submission is we erred in that regard, and it applies both to the conduct of all, it applies to the conduct of all participants. We refuse permission to appeal on this point on the basis that in a bilateral exchange with one active party and one passive party, the undertaking that discloses sensitive information cannot sensibly be presumed to take into account its own information. That we see, if the court wishes to see it, at paragraph 29 of the permission judgment, which is in Core Bundle 2, tab 19, paragraph 21, page 471. Sorry, that's it. 29. Yeah. Right, 2. So, 471, one sees what the judge said, describing our submissions. Yeah. Yes, at the bottom, the judge says, this is about 4 lines up from the bottom, but if A discloses its commercially sensitive information to B, but B does not disclose its commercially sensitive information to A, and B is able to rebut the Anic presumption, it's close to absurd. There's nonetheless a concerted practice, unless A shows that it did not take into account its own information. That self-evidently would not reduce A's uncertainty as to its competitors' conduct on the market. TFEU's reliance on the jurors is misplaced. Now, we agree it would be absurd to suggest that the Anic presumption, that the disclosure is presumed to take into account its own information. And that isn't the submission which we made. Our submission is that the disclosure takes into account the information which flows back from the receipt by the recipient of confidential information and an invitation to collude. Now, this is another point in our submission where it appears that the CMA agrees with us. And we can see that, again, if we turn to tab 27, and we look at page 996, paragraph 47, the Anic presumption applies just as much to the disclosure taking into account any information it receives from the recipient as to the recipient taking into account the information that it receives. 48. Second last sentence. In principle, information can flow in both directions, including as to the attitude of the recipient to the disclosure. And then it's having said this, where the recipient actually communicates any information about itself as a matter of evidence. And then if we go...
Yes, just on that last sentence, I'm not sure you'd agree with.
No, I don't. You don't.
Well, that's the thrust of your submissions. You say
yes,
whatever is actually communicated,
yep,
passivity must be taken as a matter of law,
yes,
to communicate cooperation.
Yes. I mean, unless we've got the... Well, we're talking about, in a meeting, we're not talking about a factual situation like a Churis, which was a factual situation well divorced from the present situation. So I would accept in a situation like a Churis, passivity may or may not. But that's because of the particular situation they had in a Churis, which is very different from this. Yeah. And if we look at 53 or 997, we see there, if a disclosure receives competitively sensitive information from the recipient, e.g. the recipient communicates its tacit acquiescence to an anti-competitive goal or conduct, the Anic presumption applies. Now, we haven't produced for the court, we haven't been able to find, nor has the CMA, any case directly in point, in the sense where it states specifically the conduct of the disclosure is also caught by the Anic presumption. But in our submission, it follows as a matter of principle that it must do. And it's notable that the presumption is described in the case law as applying to the undertakings participating in the concerting arrangements. And that's what Anic says at paragraph 121. Simply on the basis of the words used by the CJEU, the presumption applies to link from the consultation to the subsequent conduct of all participants. And to similar effect, the phrase used in the Churis at paragraph 33 is the undertakings participating in the practice. Now, it's entirely unsurprising in our submission that is the case. But it's true if the judge approached this on the basis that it's essential that the recipient's competitive uncertainty was reduced, one might see why it naturally follows that the Anic presumption is focused on the conduct of the recipient. But if we're right under ground one, then it's sufficient for the discloser's competitive uncertainty to be reduced. And if that's right, the Anic presumption must apply to the discloser whose competitive uncertainty has been reduced, just as it applies to the recipient. In our submission, if there is to be a meaningful and strict prohibition on illicit contacts between competitors that distort conditions of competition, the subsequent market conduct of both the discloser and a non-objecting recipient must be presumptively tainted. by consultation. Now, if I'm right about consultation in this case, as I invite the court to conclude, conditions of competition are distorted both from the perspective of EE, but also from the perspective of O2. And it must logically follow that in determining the causal connection between the consultation and the subsequent market conduct, that the Anic presumption applies both to EE and to O2. Now, what evidence can be used to rebut the presumption? The dispute at this stage is in a case such as this, which involves an anti-competitive meeting, is public distancing or report to the authorities the only means by which the presumption may be rebutted? We say yes, the defendants say no. This is another example of the CMA agreeing with the submissions of Phillips for you. If we turn to Core Bundle 2, tab 27, page 991, paragraph 31, I may have got the wrong reference.
Yeah, this is in.
I've got the wrong reference. Forgive me, it's paragraph 63, which is at page 1000.
53 or 63?
63, my lord.
63, yeah.
The CMA therefore agrees with Phillips that public distancing constitutes the only means available when undertaking involved in anti-competitive meetings.
Yes, I think we're going to hear from the CMA. That doesn't sit, to my mind, very easily with paragraph 56 of their submission.
Well, that's as may be. But, that's,
I mean, you could say at that point, I passed the buck.
well, our submission is that
You're going for 63, yeah.
I'm going for 63, and I'm also going to take you to the case law which supports that.
Yeah.
Now, as I say, this is a submission that the learned judge simply failed to address in his judgment. And when we came to seek permission to appeal, the learned judge rather seems to have forgotten that we actually made that submission at trial. Now, I can show you the documents, or the court can take it from me, that, and we've got in our supplemental bundle, tab 2, tabs, bundle, second supplemental bundle, tab 27, I think I may have got a wrong reference again, forgive me. Let me...
What are we looking for?
I'm looking for our submissions.
Before the judge.
Yeah, let's look at supplemental bundle 2, tab 27, page 607. Heading Public Distancing and Causal Relationship and Consultation of Market Conduct. And if we go down to 27, secondly, where an undertaking participates in a collusive meeting, public distancing is the only means by which the Anic presumption can be rebutted. Now, the court will see that that is on page 9 of what I accept were lengthy submissions. But this point was an important point, and it wasn't hidden away in the depths of our submissions at trial. And the learned judge simply failed to refer to that or deal with it in his judgment following trial. Now, and when he came to deal with this at the permission stage, again, he seems to have forgotten that this was something which we did indeed raise. Good. Page 469 of the core bundle 2, tab 19. Paragraph 26. So the submission was not advanced in these terms at trial. Well, they were. And this may be another unfortunate example of what happens when there is an extensive delay between the close of proceedings and trial, because we would suggest that it would be very surprising if a judgment given in proper time, the judge had failed to observe that submission, prominent, page 9 of our closing submission. Now, as far as public distancing is concerned, we rely on an interpretation of the Churus case, which the court finds in Authorities Bundle 12, tab 51, page 2978 again.
Yeah.
Now, our submissions in relation to the Churus case continue to be disputed, it would appear, by EE, but as I will show you, our submissions are consistent with the approach that our Supreme Court took to the interpretation of the Churus case in the Sainsbury's case.
Yeah.
Now, we have paragraphs 46 to 49, and could I ask the court to look at that? That's from 3005 to 3006.
Yeah.
Now, as we understand it, E suggests that 46, paragraph 46, is not dealing with the Anic presumption at all, but a different, albeit closely related, legal presumption.
But there is, do you accept, when you look at Anic, there are two presumptions
Yes.
that are discussed?
Yes, we do.
And the word at the moment, ground 2 focuses on paragraph 121.
Yes, it does.
But there is
There
a
is.
presumption
Yes.
about
Indeed.
participation in meetings.
Indeed. The question here is, what is 46 to 49? Is it talking about two
If we
presumptions?
go on to 49, if we just look at 49.
Yes.
I mean, that's clearly dealing, isn't it, with the Anic?
Yes, it is. And that is
Dealing with the
accepted.
presumption of a causal connection between the consultation and the market conduct.
Yes, it does. It is. That's accepted.
So that,
But what's not accepted as to whether 46 is applying to that presumption or some other presumption. And I'm going to take you through the Churus
means other than public distancing
to show
must be held. Could be rebutted by evidence of a systematic application of a discount exceeding the cap in question.
yeah. This is there's a distinction drawn here in the Churus between cases involving meetings where public distancing is the only means of rebutting, and cases which don't involve meeting, as the Churus was,
Yeah.
where it is accepted that other means can be applied to rebut the presumption.
Yes, in a sense, in Aturus, was the issue was all about whether there was participation, really, the first stage.
Yes.
Because, assuming it was common ground that if they were clearly participating in the system, they were operating the system that capped the discounts. So the only issue was really about whether they had given any form of negative or positive.
Well, there are a number of issues. Were they aware? So are they participating? That requires awareness, and I've already shown you what the learned Advocate General had to say about that. But what I want to do is to take you through Aturus relatively carefully, and that will, in my submission, show you that we're talking about the one and the same presumption in 46 and 49.
Are we really? Because you earlier, on your ground one, you earlier took us to the paragraphs just leading up to 46, did you not?
Yes.
44, 43 and 45.
Yeah.
46 is, in the third place, it's part of that line of argument, isn't it?
Well, we need to start at paragraph 33, where I haven't taken.
Indeed.
Yeah.
I'm afraid.
Well, I suggest we do that at 2 o'clock.
Certainly, my lord.
All rise in favour.